different towns around here have Southern tea. That's way better than this tea. But the closest one to us is in Branson, which is like 2 hours from here. So I ain't driving 2 hours just for a tea.
Crime charged beyond reasonable doubt. In this state, a defendant on trial may or may not testify as she chooses. If she does testify, you would judge her credibility by the same test applied to any other witness. If the defendant does not testify, which is her absolute constitutional right, you shall not draw any inference of guilt from this decision. And her decision, her election not to testify, may not in any way affect your verdict.
I hope she does testify. I don't think she will. But I hope she does, because it'd be awesome to see her fucking fumble over her words.
Verdict. Moreover, the defendant has no duty to call any witnesses or present any evidence during a trial. If she calls no witnesses or presents no evidence, you may not derive any from such failure to produce evidence. In such case, you decide on whether the state's evidence proves the defendant guilty beyond a reasonable doubt. Under our system, I have the duty as a trial judge to decide the law that applies to a case and to instruct you on it. You have the duty as a jury to decide the facts in a case from which the evidence and reasonable inferences arising from the evidence. I'm going to say that again. I don't think that was too clear. You have the duty as the jury to decide the facts in a case from the evidence and reasonable inferences arising from the evidence. In reaching your verdict, you also have the duty to apply the law to those facts. You decide the facts from the evidence. The evidence has two parts: testimony of witnesses and exhibits. A witness means anyone who testifies in person from the stand. The exhibits are those documents, objects, or photos that the court admits into evidence. You will have most of the exhibits with you in the jury room while you deliberate. However, there are some exhibits that cannot be sent to the jury room, so it will be important that you pay close attention to all of the exhibits admitted during the trial. I caution you that what the lawyers say during a trial is not evidence. Also, anything that I might do or say is not evidence. I have no leanings at all in these cases. My only interest is to have the cases tried fairly and according to the law and the constitutions of the state and of the United States. You are the exclusive judges of the witnesses' credibility. That is, you decide the truthfulness and reasonableness of their testimony. You may believe or disbelieve all or any part of the testimony of any witness. You have the duty to decide what testimony is worthy of belief and what testimony is not worthy of belief. You should lay aside any preconceived.
Being that this is 7 hours long, I'm sure there's a lot of breaks, so there'll be breaks in it. So it's not probably 7 hours, probably like 5.5 or so. Yeah, we're gonna be on this for a minute, and then there'll be day 2 will be tomorrow. So yeah, because it's not a weekend, so probably be listening to this for the next couple days.
Notions and not decide a witness's credibility until the witness has testified. Rules of law govern what the court admits into evidence. If an attorney objects to the admission of evidence, then I must rule on the objection and decide whether you can.
Probably not tonight. Like, we'll probably get through a couple hours of it.
Consider such evidence.
I'm not going to listen to 7 hours.
You should understand that there are two ways that I can respond to an objection. If I say sustained, that means the evidence. That means that I granted the objection.
Once it gets into the trial, I'll be able to talk a little bit more about it because I kept up with this case pretty good when it first happened. But there's a lot of new evidence that they brought out in yesterday's part of it that we watched, that we listened to. So I'm sure I'll have a lot to say as it goes once it gets into the actual case.
And you should